Response we got in the Justin Baldoni insurance Harco matter. There are two matters. There's one in California State Court and there's one in New York Federal Court, Southern District of New York. The Southern District of New York is the one we're talking about. Harco's the plaintiff in it. They actually were asking for a declaratory judgment because they denied coverage, and why they might do that, why wouldn't they just deny coverage and leave it at that? Well, because these are duty to defend policies as opposed to duty to indemnify. Duty to defend policies are better policies. And it's really common. I generally don't see indemnity policies, but the duty is broader. The duty starts when there's a claim. The insurance company has to defend. They have to pay the defense costs. There are some parameters around that, right? Generally speaking, insurance companies have a panel of, insurance counsel or attorneys that you're able to utilize. Sometimes they'll have a rate cap. You can't just go out and pick like your brother's firm because you really like them. Whereas duty to indemnify is basically just to reimburse you. They don't have a duty to defend you in the matter. So the indemnity is really only for covered claims, whereas on a duty to defend policy, you could have a frivolous claim, but the insurance company still has to defend you against that frivolous claim. Which does remind me to go back to the paneled attorneys. It's something I've spoken about for a while. You're not going to be able to just pick your super expensive white shoe firm. But it reminds me of something not actually Golden said, I literally think today, is she was saying how there was nobody that was evidently a employment lawyer on the Wayfarer side. It's possible that there was somebody deeper on the bench. And that also makes me wonder, because oftentimes when the insurance company gets involved, they want to make sure that it's somebody that this is really what they do. It's employment practices matters. And while Brian Friedman and his team have a whole host of great experience and are definitely very sophisticated litigators, I don't think that they really have necessarily that employment law expertise. So I guess what happened today? Well, we didn't really see a lot of meat and potato legal arguments here. This is really about forum shopping. And basically the Wayfarer team was saying this does not belong in federal court in New York. This belongs in state court in California because state laws are at issue. The Wayfarer parties are in California. There's this other lawsuit that's in California that they filed. They are the plaintiffs in the other lawsuit against the other insurance companies. You might be asking, why did Harco file for this declaratory judgment, whereas the other companies hadn't, but they've all denied coverage? Well, I would say that in my opinion here, I do think Harco's coverage is likely the one that would have responded had notice been timely. And there weren't these issues with the application and the warranty statement that could potentially preclude coverage. So from a just coverage perspective, I do think that one would be the most likely one to respond. Then maybe a media after that, which I believe was with QBE. And then potentially a GL policy, although I don't know. And I think there's a Lloyd's policy too. I need to check what the actual coverage was on that. But again, all of those are in state court in California. And so today, the basic arguments here are this either needs to be dismissed or alternatively stayed because this really does not belong in federal court in New York. And Harco was just forum shopping by filing here. And so I also do think that Harco did file for this declaratory judgment because they recognize that under the policy, their policy is likely the one that should be responding to some of these causes of action and defending them had the notice issues, which there's multiple different notice issues, had those notice issues not been a problem. And so since it's a duty to defend policy, I think they're trying to take this additional step of filing for the declaratory judgment so that if for some reason a court says, okay, this was bad faith, I think then their counter argument could be, well, we were so concerned about the denial that we took this to the courts relatively quickly to get the courts to decide on if there was coverage or not, or if our denial was adequate. Because if it is a bad faith denial on a duty to defend policy, there are instances where the insurance company can actually be on the hook for all of the costs. So you could have $1 million policy, but you could have $2 million in defense costs, and guess what? They're gonna have to pay that. There is one other thing that I noticed in here, and it was they did a brief synopsis of like some of the facts uh, in the Wayfarer response today. And part of that was around the causes of action in the lively matter. And they started with defamation, which I thought was interesting. And defamation, so an employment practices policy, which is what the HARCO policy is, it's also a DNO policy too, covered employment practices issues. So that's like harassment, discrimination, wrongful termination, retaliation, other kind of prima facie torts, intentional infliction of emotional distress, defamation, because you can have, workplace defamation, somebody in your workplace. And so they started with defamation, and I was like, that's interesting. And they never once mentioned the sexual harassment. They did mention the retaliation and the false light, which false light is very similar to defamation. And that would be included in EPL coverage. But I thought that was interesting because I was wondering if they were somehow trying to kind of sever the nexus between them. And what I mean by that is that, say they do deny for the sexual harassment portion because they say, hey, like the 17-point list was a claim and that should have been reported way sooner, or was actually potentially something that happened prior to them even having coverage. And that gets into the warranty statement that they signed when they incepted the first policy, or what I believe to be the first policy. They might be trying to sever these other causes of action from that sexual harassment. This is just my conjecture. I don't know, and I don't know how successful they would be, and I don't know if they're even going to try to make this argument, because generally speaking, interrelated claims are kind of treated as one. So when that first made claim was made, that's, when the clock starts ticking on when you need to give notice to the carrier. So I can't quite tell, but the fact that they didn't mention it here makes me kind of wonder why they didn't mention it, the sexual harassment, and it makes me wonder if there's some argument that they're going to make later on that says defamation, false light, and retaliation are separated. And I thought it was still interesting that defamation they started with. They did say among others in her causes of action, but I'm like, why didn't you list it?